And we're pleased to have Mike Flom from the Great Plant Moody law firm, the general counsel and legal ethics guru. Thanks, Justina and John, very much. And they'll be back up here again as part of the LegalCORPS players. Is a session on legal ethics issues and professional responsibility issues that come up or might come up in the course of a brief representation, either one of the in-person clinics or remote clinics. I will also mention that we've applied for CLE credit for this program, or we will apply actually, but I think it's actually we still have to do that, but we can get three hours of credit. And I think on the invitation we said we're applying for 0.5 hours of legal ethics. I think given the amount of times we've referred to it and the fact that we have a session after this, we're going to apply for an hour and see what they say. So we'll let people know. Probably won't do, if you have I happen to have a June 30th deadline and you're trying to make the ethics credits and the half hour versus an hour is going to make a difference. Probably can't tell you before then, but for others it might be helpful to know that. But be sure to sign up on the CLE lists at registration if you haven't done that. So Mike and Mike wanted to talk about some of the issues that come up. And actually in the volunteer handbook we've reprinted the relevant rules of Minnesota rules of professional responsibility that do come to bear. So let's start with Rule 1.6, confidentiality, including the duty to keep matters confidential, privacy of surroundings, et cetera, those issues that come up. Mike Vitt, I'll ask you to address that.
Well, obviously all of you as attorneys would be aware of this, but in the clinic situation, what often happens is that you will have maybe a law student assistant there. In some circumstances, it's common to have a business advisor, for instance, a SCORE advisor or a small business development center consultant that the client sort of wants to have in there with them. And the non-attorneys are not always conscious of the fact that they have a legal obligation to keep everything confidential under Rule 1.6. So we try to structure things in such a way in some circumstances where we will ask for confidentiality agreements, for instance, for the non-attorneys. So it sort of drives into their consciousness that they are agents of the attorneys there and they have a legal obligation to keep things confidential. It's easy enough when you're in the same room together to see who is all there, and you want to make sure that all of the people in the room understand that the attorney and all of the others on the counseling side are obligated to keep things confidential. In the long distance context, that's another matter where you will have non-attorneys, this small business development center consultants, for instance, who are helping make the connections and maybe have the ones who have registered the clients and all. You want to make sure that they are conscious of the fact that even their presence there is confidential. And so that's where we have it in the routine for the long distance clinics to ask to have all of them sign confidentiality agreements, and that's maybe just to educate them. We often will get the question, I'm going to repeat this much, that people wonder, is it okay if my business advisor comes in with me? And sure, it'd be okay. You just want to make sure that the business advisor understands the new world that they're entering into with legal attorney-client confidentiality.
Mike, well, I would say that in my experience, it's pretty rare for someone to want to bring business advisor
it has happened, yeah.
But I guess it has happened. So you're saying that in the long distance clinics or virtual clinics we do.
It has sometimes occurred in the non-metro in-person clinics as well.
And does LegalCORPS have a form for that?
Yes, we do.
Because I haven't had that come up, so wasn't aware. That's something that we should make available.
Where it has also happened in very rare circumstances, this is not a routine situation, but we have addressed language barriers that way. We've had a bilingual business advisor sitting in on the counseling session to help bridge the gap there, so the person can be confident that the client is understanding what is being said, and that has been an unusual circumstance, but it has happened, and we wouldn't be surprised if it happens with increasing frequency as we interact with more and more folks whose first language is not English. So.
Okay, very good. And Mike Flom, I guess I'll ask you to address it, because I assume that all of us within law firms deal with the situation of conversations in elevators or conversations in maybe public places, and just being mindful of that. But anything that you can see in our clinic setting that you'd say is something to keep in mind?
I think Mike Vitt's covered it pretty well. The important thing to remember is that the attorney-client privilege in particular is only between the attorney and the client, and confidentiality, which is even broader than the privilege, is also the same way, and it can be breached if the information is shared or leaked outside of the attorney-client setting. So when it comes to other people who are involved, if they're kind of an arm of the client or an assistant to the lawyer, that's generally fine. Of course, the rules can change in different jurisdictions. And the important point that Mike Vitt brought up about if you're long distance, if you have people over the phone, over the internet, over social media or something, is that where 20 years ago when we taught about preserving privilege and confidentiality, we talked about being careful in an elevator or a crowded restaurant that you can't be overheard. Well, if you're on the internet, now you're in a whole new world, totally unlimited, hundreds of millions of people, totally anonymous, totally unlimited. And the point isn't to not use those things, but to be careful who's there, what media you're using, if it's verbal and not video, to find out who it is that has the ability to listen in, and make sure, as Mike said, to clarify that whoever's there is within the realm and understands the confidentiality or privileged nature of what's going on. In most cases, it won't be an issue for a short half-hour or so consultation.
Right. Okay. But as we've talked about with the especially the remote or the long distance clinics, just knowing who's in the other room, whatever, like for the client to know who's in the room, it is important so that they have the ability to basically consent to that. Okay. So the next topic we wanted to talk about was attorney liability. I mean, now we have this whole the clinic is this half-hour sort of complete representation, start to finish, in a half hour most of the time. So, Mike Vitt, maybe start by covering attorney liability issues, liability insurance, whose insurance policy covers it.
Well, when LegalCORPS volunteers are volunteering in the clinic setting, we have professional liability insurance that covers our registered volunteers, and that we have a rider on that policy that makes it the primary coverage. Now, as you know, we've never had even a hint of a claim, but you've got that. If you have, if a disaster should happen and you've got claims that go over our policy limit of $1 million, then any insurance that your employer might apply to your volunteer activities would be the next in line, and then perhaps some personal assets. But it's hard to imagine in a brief advice setting anything of that nature happening. But
I've never heard of a party not being comfortable with that. I mean, there is coverage for those in law firms. Our insurance is going to cover it, but for one thing, there's never been a hint of. I mean, it's tough to envision a claim sticking. You could see somebody maybe bringing a claim, in which case lawyers have to be hired. So really, one of the big services that the insurance provides is to pay costs of counsel. So, Mike, I don't know. What are your thoughts?
Well, I think Mike Vitt covered it well in terms of the coverage that could occur. This is an attorney-client consultation, so it's possible liability could set in. It's a good thing and a nice protection for people who volunteer that they have that coverage. Most law firm policies, which would be secondary in this case, are typically going to have much larger retentions or deductibles and also larger limits, but very rarely is that situation going to occur. And I think it's a good time to talk about it as we're talking about these ethical issues and possible liability to remember another ethical rule that's not reprinted, which is 6.1, which gives all of us an obligation and a responsibility to provide these sorts of pro bono services to the underserved and poor and disadvantaged people. And I think we're all to be commended for advancing that rule. And these rules are not meant in any way to discourage or hinder or slow down the good work we're doing. So while it's important to talk about insurance and liability issues, again, this is something that's rarely going to come up. And if it does, it's good to know that LegalCORPS has in place something that's going to cover well over 99% of any circumstance that could arise.
And I would also say that LegalCORPS has gotten by just fine over the last 8-9 years, however long it's been in existence, without, with the coverage that it has and with the participation it has. And now what we're doing with providing some training, I think, and just sensitivity to it, and trying to then get that word out and having the handbook available is going to enhance that even more. So that's great.
I should just say that it's about 1 in a million whoever the clients express anything except very deep gratitude for the time. Not, if you didn't give me the answer I wanted, and so I'm heading for litigation. That's never, so.
Well,
even bringing this up, I don't want to raise any anxiety.
No, and I think their sympathies as a plaintiff would be pretty obvious. But I also point out in Appendix C, again, we've got the sample client data sheet, and that has the box at the bottom that has the client acknowledgement, and that's very important in terms of our protection and just setting the stage, setting the ground rules for the fact on a couple of things. Number one, it makes it very clear that this is free representation and this is very limited representation. And so it clarifies some of the things that you would want to clarify in terms of, this lawyer, once the clinic is done, this lawyer is not responsible for things that I screw up, where, I miss a deadline on a claim or something like that. That's not covered by this. Also understand that to get full representation, I would need certain things like a separate engagement letter and to meet income eligibility requirements. And then we'll talk in a minute about conflicts of interest, but there is a waiver of the full conflict of interest protection that clients generally get from the professional responsibility rules, because there is a specific rule that we're going to talk about in a minute. But that's all covered in the acknowledgement, and people have worked very hard on that as sort of a mini engagement letter that really covers the risk that that we might have in terms of creating an understanding. So I guess that covers you while you're giving advice in the clinic, and I wanted to raise the issue of what is part of the clinic. In other words, I've posed this for Mike Flom and wanted to get his thoughts out on it today, because there are cases where either the client knows who the attorney is or finds out and contacts the attorney, or where the attorney says, I just want to find the answer to this, and I've got a real estate expert at the firm but can't do the phone a friend today. And so can I get back to you? And is that covered under this limited representation waiver?
I think it's easiest to look at this as something of a spectrum, where the answer is easy on both sides, and we talk about what happens as we're moving back and forth towards the end, from the ends of the spectrum. On the one side of the spectrum is the basic short-term limited consultation that you have at the clinics. That's clearly something that's fine, that's handled by Rule 6.5, where you don't have to do a full conflict search except for conflicts of interest you happen to know about at the time you're sitting there. and it's limited in scope, and the client understands that, and it's free of charge. If it goes beyond that, and as you go from kind of a general situation discussion and identification or discussion of just laws and regulations and standards that could apply to something that becomes more like specific facts, and especially application of laws or standards to specific facts for that client, then you get to the other side of the spectrum. That's an actual legal representation beyond the clinic that would require the separate engagement letter and arrangements for fees, etc., conflicts, a regular type of representation like you'd have back in your own private practices or offices. But then the question becomes, what if you get a follow-up question? What if somebody calls the next day and says, say we were talking about the difference between an S-Corp and an LLC. Would it make a tax difference if we go one way or the other? And I think there you get more of a judgment sense where I don't think you should be necessarily discouraged from an easy follow-up question. Yes, it could make a difference depending on certain circumstances of the participants, and you should follow up on this, that, or the other thing. But at some point you're going to get to, you're getting more into the specific facts, you're getting more into an analysis of the sorts of things that we as lawyers do, and then maybe even drafting of documents. You're going from the general to the specific, and you cross the line. And I think in most cases it'll be pretty clear when that happens, when it's not clinic anymore, and when it goes over to an actual, a full legal representation on the other side. And I think if you think about it in terms of a spectrum with the endpoints that are the easy answers, and then how you're getting there is if it starts getting into the grayer areas, you can analyze it that way and make a judgment decision.
Oh, that's a great way to look at it. And so, Mike, Vitt, let's say that the client asks that question and there's sort of a general follow-up answer, but then, I'm the volunteer and I decide, boy, I'd really like to take this client on and give more substantive advice. Is that something I should contact LegalCorps about?
Yes, I would say so. What we generally, first of all, we want to make sure that, as we said earlier in the program, that the clients are always aware that they can come to LegalCorps for full representation and apply. And how we would like to have the attorneys at clinics and brief advice settings handle this is to let LegalCorps know that if the client is eligible for full representation, then they would like to take it on, and we'll make a note of that. We've had the occasion where people have applied for full representation. We've determined they're not eligible, and the attorney or the firm decides they want to do it anyway. That's between them and the attorney and the client. We don't want a situation where you've got moving from a brief advice to full representation without the client being aware that LegalCorps can be involved in providing free assistance in case, but the attorney-client relationship is between the attorney and the client, but because it's the connections being made through LegalCorps, we would like to have them come through for screening. And a lot of the folks who say, if they're eligible, we'd like to do it, but they are not interested if they're not eligible. So we do the screening for them. So,
well, and in fact, it's just good to have to do that through LegalCorps for various reasons, things that you might not have thought of, but also that LegalCorps as an agency needs to know and to be involved in that process and monitor that situation.
Was there a question over there? No.
Okay. Let's move on to conflicts of interest, because that's a really interesting topic. And David March, in our first session, touched on that somewhat, that you can have, and really that there are two types of conflicts of interest. And we'll talk about multiple clients and entities in a minute. But the one that doesn't come up a lot with, say, an in-house legal group, although you could imagine that it could at some point, but it comes up a lot with law firms, and that is attorney, what lengths does the attorney have to go through to make sure that there's not a conflict with an existing matter of either them or their law firm, and it's very limited under Rule 1.7. I'm sorry, it's Rule 6.5 as an exception to 1.7. So, Mike, why don't you address that?
Yeah, the conflict very basically stated that the general conflict rules that we can't take on a representation that's adverse to the interests of another client. Basic 1.7 conflict of interest. If you're working in either in a corporate department or a law firm, a small one or especially a large one, you're going to have situations in place where you check for conflicts of interest before taking on a new representation. And even that can be complicated when in a business setting when you're talking about affiliates, officers, directors, 5% shareholders, et cetera, et cetera. Good news is you don't have to worry about that generally in a limited short-time consultation for somebody like LegalCORPS or another provider of legal services because we have Rule 6.5 of the Minnesota Rules of Professional Conduct, which specifically say that that kind of a short-term representation, if you're doing it under the auspices of a program offering pro bono legal services, like LegalCORPS, gives you a very relaxed and easier to handle conflict checking obligation, and that's that you're subject to Rule 1.7 and 1.9 relating to former representations only if the lawyer knows that the representation of the client involves a conflict of interest. So you don't have to run a full conflict check. It's only if, as you're sitting there at the time, you know that that the person on the other side of the table has a conflict of interest with you of your firm. So if, for example, you represent a large landlord, and you know you do, or your office does, and you have one of these potential tenants talking about, do I need a lease and what should be in it, and you happen to know who the landlord is, you do have to put a stop to that. But if you don't know who that landlord is, you don't have to say, I got to call the office and run a conflict check. And that's what protects you there. Do you know there's a conflict check? I really think it's interpreted to mean as you're sitting there, what's in your head at that point. I don't think knowledge extends to reasonable investigation or anything like that. If the representation should change and become an ongoing or continuous or more full-based representation, those rules kick back into place, and you have to run the regular Rule 1.7 for current clients and 1.9 for former clients' conflict checks.
Yeah, that's a critical point, is when it switches over to full representation. Mike, you had a...
I want to mention a couple of procedural factors for that LegalCORPS implements that addresses some aspects of this. The first is in the non-metro in-person clinics, and this would perhaps less likely apply to the long-distance clinics, but because the lawyer communities and in the non-metro communities are much more limited, that's part of the factor what we factor in having advance notice of who is coming to a clinic, who is signed up for a clinic, and what their issues are likely to be. And if we know that what they want to address, the questions, would involve a lease or a contract or something where there's another party, we can then we can ask them, who is the other party? And so they can get advance notice so people don't waste their time, because they may walk into that clinic, they may have driven for 25 miles or something, and they come in there and say, oh, wait a minute, this lease is one of our clients, I can't consult this. That's one thing we do. The second thing, a comment, number 2 to the Rule 6.5 says that a lawyer who provides short-term limited legal services pursuant to this rule must secure the client's informed consent to the limited scope of the representation. Ergo, we have this signed acknowledgement, and that's why it's important if you're doing this. This is, it's never come up. We're papering files. But if it should ever come up, they have signed this. That's acknowledgement of the limitations of the attorney-client relationship. That, just FYI, that flows directly from comment 2 in Rule 6.5.
Yes, question.
I just had a quick question with regard to the acknowledgement. I think we said earlier that the client kind of fills out that first side. Do we walk them through the acknowledgement before they sign?
That's a really good question. The question is, do we walk the client through the acknowledgement when they sign? The answer is, I haven't seen that done. We should consider that.
It wouldn't hurt. That's all I can say, because it is very clear, it's happened a few times over the years, we get responses from clients about this, and we point out, says, well, you signed this. Yeah, they signed it. They never read it. And so is that, well, we got written evidence, but in reality, did they have informed consent?
Well, it's a good question, and maybe it's a common sense thing that the lawyer has to do, because in a 30-minute session, it's hard to see walking the client through it. But I would say if it's a situation involving a bank or a potential dispute with a bank or potential dispute with a landlord or whatever, and boy, I don't know of anything, and I'm not going to check, but I could find out next week. I mean, the waiver is very well drafted, and one of the nice things in it is that it not only acknowledges the limited limited conflicts protection, up to this date, but also says that I, as an attorney, may have something adverse to you next week, and I may go back to my office and find out that my business, our client, is suing them, and they don't even know it yet, and that's perfectly fine. So I think if there's a red flag, maybe explain it, but I think that it's going to come down to the style of the attorney. And let's say that in all these years of brief advice sessions, it's never really been tested, but it's well done. So better for the client to have more knowledge than less, certainly.
I think it's a great question, and especially if you're getting a sense that you have a client on the other side of the table who is interpreting what's going on as something, very specific legal advice upon which they might make an important decision, as opposed to this is more issue spotting for you and talking through a little bit what the options are and what your next steps ought to be, as opposed to acting definitively on a major decision based on a 20-minute, half-hour a general discussion sort of thing. So it's a really good question.
Yeah, it's great. Okay. Let's see. So, another question?
Client data sheet before they actually sit down and talk to us, though?
Yes.
Including the acknowledgments, so by the time they
come in, they have had a chance to look at it, they've signed it, they've filled out the rest of it, which doesn't mean that they understand.
Yeah, it might not hurt. It actually might not hurt to just make sure they understood what they just signed.
And, I think that it also depends on the site, because I really think that, for example, when at our old St. Paul site, it was in the SBA office, and we had the greatest coordinator there, who has since retired, and he would, I think, walk the clients through every step of the way, and he would sort of filter them, and if there were too many and somebody had to come back, he'd tell them which time to do it or what. So it depends on the site. Okay, so so I think we should talk a little bit about clients or conflicts created by multiple clients and entities. Maybe some tips on how to identify and sort out those varying interests of the clients.
Yeah, conflicts in a corporate setting can be very difficult in any situation, and to deal with it in a half-hour consultation can be especially tricky. It's important to know that if you're dealing with a business entity, just the idea that the business entity, if that's the client itself, means it's different than the constituents or the individuals who are there. If you have somebody who's got a startup, who's thinking of starting some sort of a business, obviously you can't have an entity that's your client until the entity exists. So in the ordinary course, with a lawyer or a law firm, you represent the organizers at the outset, or the sponsors, and then once there is an entity after that decision is made, you represent the entity and explain that that's different than the personal interests of the people who are involved, and sometimes encourage them to have separate representation in counsel. Is all this going to come up in your situations in the typical legal court consultation? Probably not, but the important thing is to just be aware of these rules, and the important thing is for everybody to understand who is or what is getting legal advice and who is or not getting legal advice, and if it's important to explain the difference, that your personal interests, your tax interests, your ownership interests could be different than the interests of the other people involved in the company or of the company itself, and if necessary, at some point, that those different constituencies have their own separate legal advice, looking out for those interests if it's important. Again, it's something more to keep in mind than something that's going to, I think, come up in the typical half-hour limited consultation.
Although, again, the example that we did this morning, Mike, was the situation, the very first long-distance clinic that the Target did in Hutchinson, where the camera comes on and there were eight people on the other
He
side
may
of
have
the
been
camera.
inflating a little bit.
Yeah, maybe, but it was like a reality show, and they managed to sort through it. But so you never know, but that's very rare.
It is, well, I would say it's common for people in brief advice settings to show up in multiples. They don't understand that as they develop this business, they may have separate interests, and just educating them that way is really helpful. Well,
let's try to be practical. Let's say you have a half-hour consultation with those people. Try to stay with the KISS rule. Keep it simple, because
right.
You don't want to spend 28 minutes explaining the nuances of conflicts of interest, which would be easy to do. But if you can understand and decide who you represent and don't represent, let everybody know, explain to the extent necessary what the consequences of that, and if really necessary, what the options are in terms of having separate legal representation. I think you've done your job as well as you can in that setting.
And it's true that probably most of the advice in the clinic setting would be in general for the business, but keep it in mind in case it needs to be mentioned. And we have in a couple of minutes our next session, so we can talk about that. Or our next sort of mock client session. Let's just talk really briefly. Spend just a couple minutes on just a couple more points and a couple more rules. One's Rule 5.3, which is supervision duties of attorneys, and the proper role of law students or interns or paralegals who might be sitting in on the clinic or who might be in training or whatever, and how to define those roles.
Yeah, just keeping this real basic. Assuming these aren't people who are separately in a certification for law students program, number one is, again, making sure that everybody who's involved has a full understanding of the confidentiality and privilege and protections of those. And number two, we as lawyers under Rule 5.3 have an obligation to do a few things relating to non-lawyer assistants, whether they're paralegals or clerks or whatever they are, and one of which is to have in place procedures for the compliance of those people with the obligations we have under the rules of professional conduct. And number two, to be responsible for those people's activities, especially those we know about, and to supervise them in a way to assure as best we can compliance with all of the various rules of professional conduct, the ones we've talked about today, conflicts, confidentiality, and others too, if they come into play. But it's that simple. Rule 5.3 should be consulted if non-lawyer assistants are being used in a particular matter.
Okay. Well, don't need to say a lot more about that. And there's also a common sense element to that without going overboard. Okay, well, one final thing, Mike, Flom. We have had situations where there have been attorneys that have gotten sort of close to the line on meeting with clients and saying, I do this sort of work, and if the client wants more representation, wants to know where to find a lawyer, I do this kind of work, and here's my card. And is that Rule 7.3 is about the rules for soliciting business, and when does that step over the line?
Well, in most cases, pro bono is going to be what pro bono means, for the benefit of the public without charge to an underserved portion of the public. Accordingly, it generally should not be used as a platform for trying to generate business or financial gain. So we have Rule 7.3, which says that a lawyer is not allowed to solicit for monetary gain somebody who has a specific legal issue, which you just learned about, of course, if you don't have a prior professional relationship or family relationship, or if that person isn't themselves a lawyer. So that's going to come into play here. At some point, you will have a professional relationship with this person, perhaps, and in which case you can talk about the services of your firm. In some cases, you'll be asked, this is great stuff you gave me. I see that I have a few other things I have to consider as we think about this business idea. Can I get your card if we go further with it? I don't think that's a problem. That's somebody who's asking for the contact information. And at some point, you might be able to say, if you have further questions, you can feel free to call me and we can discuss those. It's just crossing the line between pro bono services for free and an actual solicitation of business for monetary gain that's not allowed by Rule 7.3. That's the general rule to keep in mind. Again, you have something of a spectrum, and I think in most cases it'll be pretty clear when you're staying on the right side of that line. Correct side, I should say.
Yeah, exactly. All right, well, let's go to our next session of the LegalCorp players. Mike, why don't you move down to the end and keep your card here because you're the color commentator is Mike Flom. Okay.
Is it the next one?
Yeah.